Hi, I'm attorney Kevin Humphries with the Law Office of Lopez and Humphries, and I'm here today to talk to you about Social Security disability claims and some tips and ideas that go along with them. First off, almost 80% of all initial claims are denied. So you're going to have a higher success rate if you have your exhibits and evidence in order prior to applying for benefits. Some other tactics that we can utilize to get your claim granted earlier are things such as on-the-record requests. But to have a better understanding of Social Security disability claims in general, let's first talk about the burdens of proof and how they lay out with the age of different claimants. For all claimants under the age of 50, we have to prove that they can do no work. That means work even entitled less than light duty work, which is labeled as sedentary. Sedentary work is defined as a claimant being able to sit 6 hours out of an 8-hour day or stand and walk the other 2. It often involves light and can be unskilled work. A good example of unskilled sedentary work would be a parking garage attendant, where you're just sitting in an air-conditioned booth taking tickets all day. If your functional limitations don't rise to a level preventing you from doing this kind of work, then an administrative law judge at the hearing level could deny your claim. There's also other ways that you can be found disabled, even if you do meet the physical functional criteria to perform sedentary work, which is the lowest exertional level of work defined by Social Security. And that would be potentially absenteeism. If you're going to miss more than 2 days out of a month, a calendar month, then you're deemed unemployable. If your ability to focus, concentrate, or maintain pace is off more than 15% of the day, then that is also rises you to the level of unemployable. If we have enough records, medical records and evidence on your behalf early on, we can submit something to the administrative law judge called an on-the-record request. And what that basically is doing is telling in the body of a memo of law to the administrative law judge that you meet the legal listing criteria for benefits. And if you do that, oftentimes you can avoid the lengthy delay. Right now, for Highlands County, Polk County, and Central Florida, as well as in North Carolina, some people are waiting in excess of a year to get in front of an administrative law judge after they've requested a hearing. So anything that you can do to expedite your claim for benefits can be very advantageous. Another thing to know about when you're pursuing your disability claim is the judge. Certain judges have different preferences. Some require memos of law. Some judges like to inquire of the claimants. Others do not. They want the representative to inquire or the claimant to just testify on their own. In addition to that fact about the judges, some judges have very high approval ratings and others have very low approval ratings. And like any judge in any realm or area of practice, they have different favorites in terms of presenting evidence, and there's certain things that they don't like. So it's always good for a claimant to have an idea as to the expectations of the judge that they're going to appear in front of ultimately at the hearing level. There's different kinds of work that I went over earlier when I was talking about the burdens of proof. I outlined for claimants under the age of 50. For claimants over the age of 50, the standard is much less. To establish that a claimant over the age of 50 is disabled, all we have to do is establish that they can no longer do their past relevant work and they don't have transferable skills to another job. Past relevant work is defined as what the claimant has done for the last 15 years prior to submitting the application for benefits. There's also an indicia of credibility on all claimants' testimony if they have an excellent work history. So for claimants over the age of 50 years old with excellent work histories, they have an indicia of credibility in their testimony in addition to not having to prove that they can do all work. All we have to do is prove that they can no longer do what they used to do, whether that be a truck driver or a pilot. Knowing your rights is very important when you pursue a claim, and it can make the difference in you and your family getting the benefits that you deserve. Other exhibits can help you, such as medical source statements and residual functional capacity forms. A residual functional capacity form is a form that we can submit to a medical doctor or your treating physician that outlines what your functional limitations are. Oftentimes, medical records are very daft at articulating what a diagnosis is. They're even good at saying what a prognosis is for future medical treatment, and they even will articulate symptoms. But what they don't articulate and what they don't lay out for administrative law judges is how those symptoms affect one's ability to function. A medical source statement or residual functional capacity form is a small 4 or 5 page form, can take your medical doctor or treating physician just minutes to fill out, and it will outline how long you can stand at one time, how long you can sit at one time, what your postural limitations are, what your exertional limitations are. And these can prove to be very useful exhibits on your behalf in the claim process. On behalf of Lopez and Humphries, I thank you for watching this video, and I hope that if you do pursue disability benefits or know someone that is in need of a representative, you'll think of us. Thank you.